I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are knocking on the door of 164 on our compilation list. And today we are doing something a little different. We are going to be just focusing on one state. And guess what, guys? That state is not Michigan. We will be focusing on the state of Texas today. We got 5 different judges to feature on this compilation. But before I give you the name of those judges, don't forget that commentary will be left in from these proceedings previously airing here on the channel. Also, chapters will be added just in case you want to jump around the 5 different judges in their courtrooms. And also, don't forget to like, comment, share, and subscribe. Now, the first judge courtroom we will be in will be that of Judge Tyler Atkinson. Second, we will be in the courtroom of Judge Brenda Dominy. Third, we will be in the courtroom of Judge Sylvia Holmes. Fourth, we will be in the courtroom of Judge Suzanne Hudson. And last but not least, we will be in the courtroom of Judge David Fleischer. I hope you guys enjoy this state of Texas judges courtroom compilation, whatever you want to call it. But listen, let's go ahead and jump into 164.
Thank you. Okay. Can you tell me again how you want to be addressed, just so I can add notes in? Is it just use Timothy? Okay, cool.
That's it.
Sure.
All right. So is the court attempting to enter a plea on my behalf? Because
we have to. Yeah, we have to.
No. I would not. Again, I specifically said I am not pleading to anything. Okay. Now I'm not entering any plea whatsoever, not of guilty or non-guilty or no contest. I am not entering a plea whatsoever. If the court is attempting to enter a plea on my behalf, how do I get a recording of these proceedings? I will need a recording of these proceedings so that I can submit it to the Federal Court of Complaints.
Yeah, give me a half a second. I'll find the law for you. Is it 45 or 45A? Yeah, the Texas law says if somebody refuses to enter a plea, the court has to enter a plea of not guilty for them.
What law is that?
It's Texas Code of Criminal Procedure.
Is it a law or is it a statute?
I'm not playing that game with you.
No. I'm asking you a question. Okay, well, tell me
it's
what
a
it
Texas
is.
statute, Court of Criminal Appeals. So Texas Code. Texas Code of Criminal Procedure is the statute. Texas Code of Criminal Procedure.
Okay, so it's a code. Okay, 1 second.
But I mean, all of these issues are pretrial issues that we discuss. I'm fine talking with you now. That's perfectly fine. But are issues that we can discuss at a pre-jury hearing.
Well, in order for me to sign that paper, I would have to.
I don't need a signature. I told my clerk
entering saying that. Well, she's saying that I have to sign it, and if I don't sign it, I'm going to have a warrant out for my arrest. And I told her I did not enter a plea of not guilty, so therefore I can't sign it.
My clerk's I'm gonna have my docket clerk go up there and help solve that problem. We don't need a signature from you.
How do I get a recording of these proceedings?
I mean, you can file that request. What is it that you need? Yeah, there we go. I found it. I can show it to you. Hold on.
I just need to know, how do I get a recording of this for right now? Right now, I really want to know, how do I get a recording of these proceedings? I need to get this.
Yeah, I mean, you could file that request in writing. There it is. I'm showing it to you on the screen.
With who?
To the court. Yeah, to the court. Yep. If a defendant refuses to plead, I'm showing it to you on the screen. If a defendant refuses to plead, the judge or justice shall, I have no option, shall enter a plea of not guilty.
Okay.
I don't know how to interpret that any other way. I mean,
that's fine. It's a statute.
Yeah.
You guys, you do what you feel you have to do. So I'm just trying to make sure, if I submit a request for the recording, this recording of these proceedings to, I guess, is it the Denton Municipal Court clerk?
Sure. Yes.
All right. And I'm going to be able to get a recording of these, of saying that I did not enter a plea and that you guys had to enter a plea. It's a code that you guys have to follow. Code, not any law.
Yeah, I'm not going to guarantee an outcome, but that's where you would submit a request is through the court clerk.
Oh, so you guys don't guarantee that I'll get a copy. Okay. There's no guarantee that I'll get a copy of these recordings.
Yeah, I can't give you legal advice on how to handle a process issue.
No.
But you can submit that request to the court and the court will review it.
Okay, so, and is somebody coming up there so that I don't have to sign? And is there going to be a warrant out for my arrest if I do not sign?
No. I
will
don't like
be
talking
up there.
about warrants. Yeah.
Timothy,
Well, she told me,
Timothy, I'll be
Yes.
up there in just a minute.
Bailiff's
Okay.
going to
Walk
help.
down to the courts with you and we'll get it taken care
because
of.
I'm going to show up for my pre-trial.
Just hang on.
And I'm going to
We're
make
done
sure
here,
I
Tim.
want
We'll be there in
a
1 second.
jury trial. I'm going to follow all the processes. It's
Perfect.
just, she said I
Yeah.
had to sign
No,
in
you're
order,
good.
or I was going to have a warrant. And
Yeah.
on that paper, it says plea of not guilty. And I specifically
Cross that out. If you don't want to sign that, cross that out. Yeah, you can cross that out if you're not entering a plea. But you don't have to sign. I'm telling you, you get to take that paper home with you without your signature on it. But I just want you to have the court date. That's my only thing. I want you
Okay.
to know when to come back, but I don't need a signature from you.
And I
Like,
just want to make sure I'm not going to have a warrant out for my arrest by
No.
not signing it.
no. Yeah.
Okay.
Yeah.
And I'm
If
going
that was told to you, we'll fix that problem. But
okay.
yeah, but
I'm going to submit a request for these recordings.
if you want, yeah. Bailiff is coming just to make sure that you're good and that you have the paperwork that you need. You're not in trouble or anything like that. But he's the nicest person in the
I
world.
appreciate Officer Todd
Yeah.
coming to help me. I appreciate
Yeah.
it. I'll welcome him.
Perfect.
Okay, that's it.
Awesome.
I just want to make sure I'll be there for whatever the trial date is,
Perfect.
but I'm not signing that paper that says I pled guilty because
You don't
I
have to.
explicitly did not.
Yep. You don't have to. You're good.
All right.
Are you on the Constitution? Sure.
The what, Mr. Jones?
Are you on the Constitution?
Yes, sir.
No, we don't. If you was on the Constitution, why did you refuse to accept a complaint attempted to be filed by me, called in your office 2 or 3 times?
Mr. Dennis, remember everything you say can and will be used against you in the court of law.
I'm under the Indian authority.
Okay.
Yeah. And also, since this being recorded, the United States has been dissolved. The courts, the police, the whole 9 yards has been dissolved. I'm under Indian authority. That's who have authority over me. Not expired, dissolved corporation. So this your refusal to accept my complaint, what resulted to this day in Jacksonville, Texas. You will not accept the complaint. Sheriff, I called your office and I talked to you personally. Up under 22 USC 912. Are you familiar that the United States corporation has been dissolved, Sheriff? Under 28 USC 912, and the police officer acting under the corporation of the United States vacated his oath and is
Yes.
acting.
Remember, everything you say can and will be used against you in the court of law.
Carter 28 USC 912, and the police officer acting under the corporation of the United States vacated his oath and is acting in an individual capacity as an illegal security guard operating under an illegal government. unconstitutional court. In proceedings, do not have the authority, and it's arbitrary. I am a sovereign American Indian. Therefore, this court do not have jurisdiction. So I'm requesting to be brought before an international court with jurisdiction, custom, and I'm protected under unit drift and A drift.
Mr. Dennis, the arraigning judge will visit with you here in a second.
The judges are dissolved by the presidential notice to the patrons on January 4th, 2025. Are you familiar with that, Sheriff?
No, sir.
Well, it is, and I ask that you look into it. The corporation is dissolved.
Yes, sir.
Yeah. The courts, the police, the judges, the sheriffs, all haven't been dissolved. By President Donald J. Trump, before Attorney General Pam Bundy. So you're acting illegally, unlawfully. So what 5-0 consent have you been given authority from? Because this is an illegal government. And the arrest has been ordered by the president himself because of this breach of oath of office. So I do not consent to these proceedings. They are illegal and unlawful. If you're not, we are under common law 1776 as defined under Magna Carta 61. Are you recording this, sir? It needs to be recorded. Yeah. So, Sheriff, you're acting illegally and unlawfully because all departments has been dissolved. January the 4th, 2025. And I'm an American Indian. I'm not under the same laws, rules, regulations, and codes and policies that you are. And that is not law. Not only have you committed treason, you've been found guilty of crimes against humanity and war crimes. Now, a corporation do not have authority over natural human man. It's Penhollow versus Don Administrator. Also, Rodriguez versus Donovan.
Mr. Dennis, will you please stand up? Please stand for me.
My back is stuff messed up, man.
My help, okay?
This arm is broke. Stand what? I'm not before no.
Stand right there. All rise.
Your Honor, are you aware that the United States Corporation has been dissolved by the President on January the 4th, 2025, and that I'm American Indian and you have no jurisdiction over my... No corporation has jurisdiction according to Penhollow versus Don, and also Rodriguez versus Donovan.
Okay.
So you've been found guilty of treason by the courts, and
Mr. Dennis,
do-
you're Bobby Michael Dennis?
I do not consent to these proceedings.
Okay. I have to go. I am Judge Dominy. I'm going to go ahead and read your rights.
I do not consent to these proceedings because the corporation has been dissolved, ma'am.
Okay. I have to read your rights to you by law, okay?
I do not consent to these proceedings, ma'am, because the corporation has been dissolved January the 4th, 2025 by President Donald J. Trump.
I'm going to go ahead and read your rights to you, Mr. Dennis. You have the right to hire an attorney to represent you. You have the right to have an attorney present prior to or during any questioning by peace officers or attorneys representing the state.
I object to be...
You have the right to remain silent.
Consent.
You're not required to make a statement. Any statement made by you can be used as evidence against you in court. You have the right to stop any questioning or interviewing at any time.
I'd like to stop it now because you don't have any authority.
You have the right to have an examining trial if you're accused of a felony.
The corporation is dissolved.
You have the right to request appointment of counsel if you cannot afford counsel.
Do you not understand that the United States Corporation is dissolved up under 3002-1580?
Do you understand those rights that I just read?
I do not.
Would you like for me to
I
explain
still
to
do
them
not
again?
understand because I'm under God's law, not the laws of man now.
Okay. You have the right for an attorney if you cannot afford one. You have the right
I
to
do not understand, ma'am.
request an attorney. You have the right to stop any question at any time.
I'm attempting to stop it because the United States Corporation has been dissolved, ma'am, by the President on January the 4th, 2025. That will be a Saturday.
Okay.
And also, you being a corporation do not have a rights over a living natural man. I am a living natural man, ma'am. That's under Penhall versus
Mr.
the Honor
Dennis, I
Administrator.
am, by law, reading your rights.
Are
I'm
you-
going to go ahead and tell you.
Do you have the authority
I'm going
from
to
the
go ahead
Indian
and tell
Authority?
you what you're being charged with, okay?
I do not understand
By
or
law,
consent.
I have to do that, and I'm going to give you your charges,
You're not under
okay?
constitutional law, ma'am. So
Interfering with public service animal, state jail felony, you have a bond in the amount of $100,000.
I do not understand.
Attempted capital murder of a peace officer, that's a felony 1, and it's a $1 million bond set on that. Obstruction or retaliation, felony 3, $150,000 bond. Another obstruction or retaliation of felony 3, a $50,000 bond. And there is a federal hold on you for a federal
I don't
offense.
understand. Well, up under 28 U.S.C. 912 said any police officer acting under the corporation of the United States vacate his oath and is acting in a individual capacity as an illegal security guard operating under an illegal government. This is what this says.
Okay.
Yeah.
So do you want to request an attorney, or do you plan on hiring an attorney, sir?
No, I do not give consent. This corporation has been dissolved again,
Okay.
and that
I will tell
this is
you at
acts of
any
treason.
time, sir, at any time, if you do not hire an attorney, you can request that the
I
court
do not
appoints you an
consent
attorney.
to a dissolved
Okay.
corporation.
I do need you to
I'll
sign your...
judge, I will not sign anything
Okay.
because I am American Indian, not under your jurisdiction. Who
Okay.
give you authority,
So
ma'am?
you're refusing to sign your
I
magistrate's
do not
warning?
understand, ma'am, who give you
Okay.
authority. The courts and
Okay.
judges have been dissolved
all right.
again, January the 4th, 2025. I do request the Attorney General Palm Bondi be appointed. I do request that.
Okay.
And I request that the American Indian Authority be notified as well to you having been charged. And I'm protected of my unidrift and A-drift.
Okay, Mr. Dennis. That's all I have for you to tell you today.
Do you all in regards? There must be a grand jury indictment, not by information, as according to law, course
Okay,
of law,
you're
up
not-
under Constitution.
I'm not holding a trial right now.
No,
that
it
you'll
doesn't
go to
matter,
court
but
on
that's in
okay?
the warrant for
I'm
arrest.
just the judge, the
You're not even a
magistrate
judge. All
that
been
reads you your rights
dissolved.
to you, okay?
I'm not under
All
your
right.
jurisdiction.
Mr. Dennis, you
Okay.
can go ahead and return. Thank you, sir.
All courts have been dissolved. All courts.
725 Urban Oaks doing business as Urban Oaks versus Jose Martinez, Nicole Lewis, and then the other occupants of 6725. So who do I have on behalf of Urban Oaks?
Keith Wolfshall, Your Honor.
Good morning, sir.
Good morning, Your Honor.
Do I have someone for our first defendant, Jose Martinez?
Yes, we're here as a special appearance only, and Nicole is also in a special appearance as well.
All right. Mr. Martinez, what is the reason you're saying it's a special appearance?
This is a special appearance because we are challenging jurisdiction and we do not participate in legal contract.
Okay. What is the reason you don't think the jurisdiction exists?
Because it has to be proven. Whenever there's a challenge.
That's not a jurisdictional thing. Jurisdiction is either it's something I can't hear, but evictions are solely the province of a justice court. So the only other jurisdictional issue would be if the property is not located in the precinct. To your knowledge, does that address physically fall within the bounds of precinct 3?
I don't believe it does. That there's no personal jurisdiction. There's no personal jurisdiction. There might be subject matter, but in order to hear a case, you have to have subject matter and personal jurisdiction at the same time.
Mr. Martinez, if you're appearing in court, you've been served, and if you are indeed an occupant, then that would be sufficient for them to have personal jurisdiction and for the court as well.
That's why we're challenging jurisdiction. And the law says that whenever we challenge jurisdiction, that the court cannot proceed unless they provide to us, both of us, Nicole Lewis and Jose Martinez, proof that y'all have any jurisdiction.
All right, well, I'll take the information from Urban Oaks, but we'll find out. All right, then. Mr. Wolfshall, please tell me first, why don't we address the jurisdictional issue? Is this property located within the bounds of Precinct 3?
According to the maps of Travis County, yes, Your Honor, they are.
Internet just like a hall. I can't hear
the maps.
Mr. Wolfshall, I was not able to understand you. You broke up a lot.
I'm sorry, Your Honor. Is this any better?
That's better. Okay. Tell me about location. Is it in Precinct 3?
My apologies, Your Honor. Can you? Okay, thank you. Yes, Your Honor. According to the maps of Travis County, the precinct, this property does lie within the precinct of Precinct 3, jurisdiction of Precinct 3. We'd ask the court to take judicial notice that 6725 Urban Oaks is in this precinct.
On Circle Road at Congress and William Cannon? Mr. Wolfshall, is that the address?
I'm sorry, Your Honor, you're breaking up on me?
Is the address 6725 Circle Road?
I'm sorry.
Mr. Wolfshall, your internet
I'm sorry, Your Honor.
is bad.
I'm sorry, Your Honor. The address is 6725 Circle S Road, Austin, Texas, 78745.
All right, I pulled it up on the map. That is within Precinct 3. So we have both personal jurisdiction and subject matter jurisdiction. So Mr. Martinez, Mr. Lewis, I do find that jurisdiction exists within our court. All right, Mr. Wolfshall, let's go. I'm sorry, sir?
We don't consent to that unless it is proven to us in writing that there is jurisdiction.
Mr. Martinez, I'm saying that I found proof sufficient. You can appeal if you don't agree. Okay?
Well, no, that's not the law. The law says that we have to go to the
law, Mr. Martinez. As long as you are showing up, the plaintiff need only show me that they have served the defendant in the result, which you've not denied that you are Jose Martinez. He has established for me that is an eviction wholly within the precedence of a justice court, and that the address for which the eviction is sought is one which is in my jurisdiction. That is all that is needed.
But also it says that we don't participate in legal contract, and that would be.
Mr. Martinez, are you currently residing in the apartment they're trying to evict you from?
I don't understand your question, and I don't understand your jurisdiction.
Mr. Martinez, I'm going to ask that you just be silent and let me go through the plaintiff's case, and then I will answer all of your questions for you. Okay? All right, Mr. Wolfshall. So it's an address that's in the precinct. What's the reason the eviction is being sought?
Your Honor, this is an eviction for non-payment of rent.
Non-payment. Is there a written contract with the defendants?
There is, Your Honor. It was entered into on November 6th, 2024, and it expired on October 31st, 2025. We're now in the secondary phase.
Mr. Wolfshall, is that contract with Jose Martinez and Nicole Lewis?
It is, Your Honor. There is a copy that was provided to the court as well.
How much is the monthly rent per that lease?
$1,464.
All right. Any subsidy?
It is not, Your Honor.
Mr. Wolfshall, you broke up. Was that a yes or a no?
No. The last question is, it is not subsidized, Your Honor.
All
It
right.
is not subsidized.
What months of rent have been unpaid?
October through the present,
Is this a CARES property?
it is, Your Honor.
And when was the notice provided?
September 10th of 2025 I apologize, Your Honor. I did not write that down. Give me just one moment. Let me make sure I'm telling you the truth. All right. It was by first class and certified mail on September the 10th, 2025. It was also a 30-day notice to vacate.
All right. To your knowledge, the tenants have not vacated?
They have not vacated, Your Honor.
All right. What unit number is it, Mr. Wolfshaw?
Yes, Your Honor. That is going to be unit 1240.
All right. Mr. Martinez, Ms. Lewis, good morning. Mr. Wolfshaw says that you have a lease with the apartment complex for unit number 1240, and he provided me with a copy of that lease. Do you recognize this document?
Yeah, that contract is expired.
Is this a contract that you entered into, Mr. Martinez?
That's not the original one. The original one was signed in wet ink. That one is signed by electronic signature.
All right, so you have a contract that you signed. Is it for the apartment number 1240 there at 6725 Urban Oaks?
It was, but it's expired.
All right, are you still currently residing in unit 1240?
Yes, we are.
When's the last time you paid rent?
I'm not sure.
All right, the landlord here says that the rent is $14.64 a month. Is that correct?
I'm not sure because we were getting assistance from a foundation for the home.
Lease. What does it say in the lease that you said you signed? On this one, I see it to be $14.64.
Right. That's probably the foundation was paying for that. So they were the ones that were doing all the paperwork for us.
Do you have any proof that they are paying the rent on your behalf? Because the lease says that y'all owe it.
Yes, we do have proof. They were sending checks from City of Austin Foundation for the Homeless to the apartment complex that they were paying the rent.
All right. Do you know if rent has been paid for October?
I'm not sure.
Ms. Lewis, do you know if rent has been paid on behalf of October?
I'm not aware.
All right. And Mr. Lewis or Mr. Martinez, Ms. Lewis, have either of you made payment, or do you know if payment has been made for November?
We're not sure.
All right. Well, they do find the landlord has met their burden then to show that per their information in the ledger and the lease, rent remains unpaid for the past 2 months. Mr. Wolfstrom, are you wanting to prorate the rent through the hearing or through the appeals deadline?
Your Honor, just for today, I calculated that as $3,028.
All right. So you are prorating?
Yes, Your Honor, we're prorating.
Today is the 18th. So for 18 days, I got $48.80. So that's $878.40. So with that and the $14.64 for October, judgment for the plaintiff, $2,342.40. If either party wishes to appeal, we'll put that at just the 1 month of rent. That'll be $14.64. Ms. Martinez, Ms. Lewis, you both have at least 5 days to appeal before the landlord can seek a writ of possession. We will send you the information related to that. I'll highlight for you, for all parties actually, in a non-payment case, you may be able to appeal, and if you've been receiving assistance from a rental agency, you might even qualify to appeal for free. However, if you want to stay in that apartment while the case is being heard to another court, you do have to pay full rent of $14.64, but you pay it to the court, and we'll send you specific information about that. All right. Any questions, Mr. Martinez, Ms. Lewis?
Okay.
Yeah. We also submitted a VAWA case, Violence Against Women's Act, that was also violated back in July. And we submitted the VAWA Act. So they're in violation of the VAWA that prevents us from being evicted according to VAWA Federal Act. And we submitted it and they did not respond or help us on that VAWA Act.
All right, Mr. Martinez, unfortunately, that does not work as a defense to non-payment. I would absolutely encourage you to reach out to legal aid with that issue and with the others and see if they can assist you. You have at least 5 days. If you take no action sooner, day 6, the judgment becomes final. All right.
We don't accept or consent to the orders. So
All right. Well, Mr. Martinez, whether you
It's our
consent or
record.
not, that is the order of the court, and it will become final, and the judgment would be sufficient for the landlord to move forward with a writ of possession and removal of you and your property. So please contact legal aid in the next several days to see about an appeal. All right.
well, we don't call it legal aid.
Good luck. All parties are excused. Thank you.
Mr. Bishop, we have the defendant, Vincent Luis Haynes. He's facing 2 charges, expired registration and failure to maintain financial responsibility, and a motion to dismiss. Mr. Haynes, can you please, there you are, Mr. Haynes, there, unmuted. All right. So, Mr. Haynes, do you wish to summarize your motions at this time?
Yes.
Go ahead, sir.
In my notice of abatement, I am asking for the court to show that it can uphold the Constitution in reference to Article 6. I am basically stating that I am a natural person. You know, I'm in the court even currently right now with my Lord and Savior Jesus Christ, and the notice of abatement just goes to the heart of the matter as to the jurisdiction, both subject matter and personal jurisdiction, and to make sure that these proceedings are done to assure equity and fairness. I realize that this court may not provide a remedy for me. And so at that point, I'm asking for adjunctive relief, if that would be appropriate.
Mr. Haynes, you're using terms that are civil terms. This is a criminal court. These are Class C criminal charges, which carry a fine as their punishment. This is not a court that gives a remedy to a defendant. You are charged with a citation. You are charged with a crime based on the actions of a police officer.
Who did I offend?
No, sir, hang on. I'm not done.
Okay.
So I want to make sure you understand you're using civil terms. The rules that apply in this court are the Texas rules of criminal procedure. And those are the rules that dictate how the hearings and trials will proceed. And it is the Texas laws which grant this court jurisdiction in these matters. I'll make sure you understand that. If you wish to continue to summarize anything, you may, but I want to make sure you understand you're using civil terms. This is a criminal court.
Okay. Even in a criminal matter, ma'am, I still have a right to face my accuser. Again, that's what the abatement was about. And who accuses?
Sir, hang on a second. You haven't gotten to that point yet, because this is a first setting, and if you plead not guilty, there will be a trial. But as you've seen here tonight, many people plead no contest or are guilty. Therefore, there is an opportunity to hear and have all the accusations presented in court. You just have not gotten there yet.
Yeah, I don't understand that.
Okay. Well, Mr. Bishop, does the state have any response to the abatement motion?
Yes, and I'm just seeing this motion for the first time tonight, but it appears he says that the court lacks subject matter jurisdiction over this ticket, and therefore the action should be abated. And I'm summarizing that. The state's response would be that this court has jurisdiction to hear citations for traffic violations and Class C misdemeanors in the city of Dalworthington Gardens. And so it appears these tickets were all alleged to have occurred in Dalworthington Gardens, and therefore we respectfully request that the defendant's motion be denied.
Your motion for abatement or notice of abatement.
It's a notice.
Your notice of abatement is filed, sir, but there's no action that this court is going to take at this time. And you have filed a motion to dismiss. Before we go into that, sir, there's a couple of things that I want to make sure to put on the record. You've been here in the Zoom courtroom tonight. At the start of court, I went over rights and options that defendants have. Did you hear those rights and options, sir?
I heard the rights and options that's pertaining to those particular defendants, yes.
Yeah, that was to every defendant set here tonight. Do you have any questions about those rights and options?
I mean, I don't understand them pertaining to me.
Well, they pertain to you because you have received a citation and you're charged with this offense. You may not agree with it and you may not like it, but they apply to you because you were in the city of Dalworthing and Gardens and received these citations. So that's how they apply to you. Now, as I warned everyone at the start of court, you have the right to be represented by an attorney. And if you wish to have time to consult with an attorney, please let me know and I will give you a pass until next month's docket. Otherwise, if you do not have an attorney hired to represent you, you will be held to the same standard as if you were an attorney. So at this time, sir, do you wish to represent yourself or do you wish to have a continuance to consult with an attorney?
I'll represent myself.
Okay. All right. All right. And if you do not have any other questions about the rights or options that I went over at this time, we can proceed now to the motion to dismiss. If you wish to present that at this time, you may summarize your argument for the court at this time.
The motion to dismiss comes from the fact that I put a notice of abatement in, and I never got a response from my notice of abatement. Just basically asking the court, for its jurisdiction. You're explaining how your jurisdiction kicks in, but it's not relating to what I'm saying. I don't go by misnomers, and I seek, the honorable court to apply fairness, and equity. This court does not state whether or not this is a court of equity. You're telling me right now that this is a criminal court. You're saying that this is a criminal case, and you're not really presenting a crime that I see that would be tantamount to criminal proceedings. But again, everything is laid out in a motion to dismiss, and I feel that it is warranted because the court does lack subject matter and personal jurisdiction in this hearing.
Response from the state, Mr. Bishop?
Motion to dismiss should be overruled, Your Honor, or denied. State has jurisdiction here. This individual was using the roads or highways of the state of Texas. And by doing so, as is driving being a privilege, not a right, was bound by the laws of the state of Texas when driving. The allegation is he has violated those laws, and so this court would certainly have jurisdiction to hear those citations. I believe there are two of them. One is registration. The other one is failure to maintain financial responsibility.
Court has reviewed the written motion to dismiss, has heard the summary from the defendant, Mr. Haynes, response from
I object, Your Honor.
I'm sorry, sir, what did you say?
I said I object.
To what, sir?
Because there's no city, state, or government that should make a rule or law that abridges my right to the freedoms and the privileges of the continent or the land of the United States. I'm a natural born man.
Okay.
And
That objection, sir,
I have a constitutional right to be.
Sir, I've heard the objection. Your objection is overruled. All right. Your motion to dismiss is denied at this time. The allegation in the citation which you signed states that you committed 2 violations in a location that is within the territorial limits of the city of Dalworthing and Gardens.
You have the actual ticket?
Sir, you need to be quiet and listen. Within Tarrant County, within the state of Texas that establishes subject matter jurisdiction for this court to hear this matter. The court has not made any ruling in regards to guilt or innocence at this time. However, that does give the court authority to hear this case. Therefore, your motion to dismiss is denied at this time. Now,
Do you have
sir,
the actual ticket, ma'am, that I mailed back in?
I don't know if you mailed it back in or not, but I have the copy that you received notice at the time and that you signed it. And that is all that is required.
I signed it under duress as well.
All right, sir, are you ready to proceed to trial tonight on your cases?
Proceed to trial tonight?
Yes, sir. This is the contest docket. You've indicated you wish to represent yourself, and you are facing the 2 charges of expired registration.
I need
and
to have
failure
a
to
trial by
maintain-
jury, ma'am. Everything's
Okay, well, we're going to get to there. So to the charge of expired registration, how do you wish to plead, sir? Guilty, no contest, or not guilty?
I make no plea, ma'am. I'm not pleading. I do not accept your jurisdiction.
Well, that's the step to getting set for a jury trial, is if you're going to plead not guilty. Are you pleading not guilty and requesting a jury trial?
There's no plea that I'm making.
Therefore, the court will enter a plea of not guilty for you. And you've indicated you wish to have a jury trial. Is that correct, sir?
The jury trial, yes.
Okay, so enter a plea of not guilty, setting you for a jury trial. So we're going to set you for a pretrial docket, and that will be September 3rd at 7 p.m. You will get a written pretrial order. You need to read it over. It explains what you need to do and the timing. If you have any motions that you want the court to hear as far as discovery or anything of that matter, they needs to be filed at least 14 days before the pretrial hearing. If you have any evidence you wish to be able to present to the jury, you need to have that marked and filed with the court according to the pretrial order. Once we have the hearing on September 3rd, you will be scheduled for a jury trial, which we have during the day. So make sure that when you come on September 3rd, you're aware of your schedule and any conflicts that you might have for September and October.
Thank you.
You will get a written pretrial order and you'll get a reset notice. We'll see you back here on September 3rd at 7 p.m. You are released at this time unless you have any question regarding the scheduling, sir.
You say back here, this is going to be on a Zoom call again?
Yes, the pretrial will be on a Zoom call. Yes.
Okay, and I'll have instructions relating to all of this as well.
You'll get it all in writing. It'll be signed by me, and you should receive it early next week, if not earlier.
All right.
Okay. Just watch your email, check your spam folder, because there will be some attachments, so they might go to spam or junk if you have that. All right.
If I have any questions, I'll make sure I call your clerk.
Call, or you can send them in writing, either way. All right.
All right.
Okay. This concludes your hearing. You're released at this time. We'll see you back for your pretrial hearing September 3rd.
Yep.
Good morning, Judge Fleischer. How are you?
Hey, what's new?
We're on that Eaton, that pro se defendant, Mr. Eaton, to go with a discovery that he has come to look at. Our investigator has reached out to him. He's in the courtroom right now.
Are you talking about Mr. Emiton?
Emiton, yes.
Okay, hold on a second. Let me get on the record because I don't want to do anything without being on the record. So, Mr. Emiton, come on up.
We will be going on the record, so hold all conversations.
Mona, ready?
Yes, Judge.
All right. Today is time set for discovery. It is November 20th, 2024. It's approximately 11:49 in the morning. I'm going to have you guys announce yourselves for purposes of the record. Please state.
For the state, it's Emerson Marnathan and
Morgan Harmon. Judge, hold on. Can you have him come over so that I can see him? Emery, right here. Yeah. Okay, go ahead. State it again.
Emerson Marnathan for the state.
Morgan Harmer for the state.
So what we have here today is we have Mr. Emitom. He is charged with unlawful carrying of a weapon. I want to say today is our third setting or fourth. I think it's our fourth setting today. Mr. Emitom has chosen to represent himself. I have done a Feretta hearing, found that he is and can represent himself. Mr. Emitom, are you sure you don't want a lawyer to help you out? Do you want a lawyer to just stand by to be able to answer any kind of questions? Okay, you still want to represent yourself. Understand that if any time you would like a lawyer, I'm happy to provide you one at no cost to you that can advise you in any way that you may. So that is always at your disposal whenever you need it. At the last setting, we were working on discovery to see what was available. And the only thing, if I remember correctly, the only thing as way of discovery was an offense report that was in.
So Your Honor, the discovery is in, there is a video, there is a body cam and dash cam that's in. The state has tried to reach out to Mr. Emitom to schedule a time for him to come in to review this discovery. It is the state's policy to not give this discovery out of the office to pro se defendants. He is here today. We can coordinate with our investigators for him to come and look at what we have. There is also a motion to suppress filed on the same transaction felony out of this, and that is scheduled for December 6th, 15th, I believe, or 9th.
December 12th is my next.
December 12th, okay.
December 12th.
Are you representing yourself in the felony case as well?
Yes.
Okay.
Judge Lacayo did find him competent to do so, and we are having a suppression hearing on the 12th of December for that case.
Okay.
So if the evidence is suppressed, both cases would be resolved based on the search, because unlawful carry is tied to our transaction, which is a commission of a felony offense. So if our case goes away, your case goes away.
Are you upstairs as well on his case
I'm
upstairs?
on the felony case, yes.
You're on the felony case. Okay, great.
I know the last time we was here, I did the suppressed evidence. Are they doing the misdemeanor and the felony together with the suppressed evidence? Because I emailed, I don't know if it's Anna or I have it on my email. I emailed Friday, tried to review the evidence, but I didn't get a response. I got a response to come tomorrow at 1:30. I didn't make it in town till yesterday night.
So the defendant emailed me on Friday and he reached out to review the evidence. I requested a cause number. He provided the cause number, and I sent on Monday at 7:20 a.m. Would tomorrow work to review the evidence? Please let me know if you have a preferred time. I'm available anytime after 1:30 p.m.
Here now, is it possible to do it now?
Let me coordinate.
Or perhaps later today, since he's here.
Later today, let me go talk to our investigators, make sure they can supervise him. And
You're here now.
Yeah.
I would, Mr. Emitom, you're set for a suppression hearing, December 12th. You have, at a minimum, got to look at every single piece of evidence that's out there before you even go to your hearing. It would be a fool's errand to go to this hearing without looking at every shred of evidence that's out there, because you have to know what they have.
Yes.
And what they're going to use to prove, you know?
Last setting they did go in the back room and let me see whatever was like the report that was typed up and everything. So
Yeah.
I was able to.
That's just an offense report. But here, he's saying there's body worn camera.
Body worn camera, there's another video as well that was uploaded as evidence. And then I believe there was an image of the stolen check. That was.
You want to talk to your investigator now, and can you stay here and perhaps maybe like at around 2 o'clock, meet them at the office and then go through all the evidence then? Is that okay?
Yeah, I can do that. I can.
You're here.
Tomorrow, I mean, yeah, I can do that now.
If
You might as
tomorrow,
well.
if you want to come in tomorrow morning,
Yeah,
that gives us time. But he has to confirm with us because ADA Harner has emailed him, and he has to make that call. Like he can. I don't know. The body cam could be 4 or 5 hours of body cam because there's multiple body cams. I don't know if our investigator is going to stay till 7 o'clock to review body cam today.
That's a good point.
So if
don't
you're available tomorrow morning,
we do it tomorrow morning?
Yeah, that's fine. Also, are they gonna have the medical record for the hemp? Are they gonna have the?
So that is the one piece of evidence we're still waiting on, Judge, is the lab for the marijuana.
Check the charging instrument.
I'm telling you, it's based on it.
That takes a long time. Mr. Emitom, it takes a long time.
I had the receipts from, because they had Montana Doyle that was claiming that. I do have the receipts, and she was my witness. That it said that she was claiming that. It said it in the report, so my witness could come and do the testimony or whatever.
But that's at the hearing.
Okay.
You do that at a hearing.
Okay.
You don't do that here as part of just evidentiary sharing, right? It's not, no one takes testimony now. No one decides.
Last one, they said she could do it with the clerk. When I did have her here, they said that the clerk could.
You mean just filing an affidavit?
Or whatever she needs to do to say,
I mean, I can't tell you. You're representing yourself. That's why you usually have lawyers that kind of guide you on how to get evidence admitted, what kind of evidence gets admitted. I can't give you legal advice, and they can't tell you either.
Yeah, they said I could submit it to the clerk. That's what they said. The witness could come to the clerk and do.
Who is they? We didn't say that. All I said is that if you wanted to file an affidavit, yeah, something like that. But
I have to do that.
So can you talk to your investigator? See,
Yes, I'm gonna do that
tomorrow, perhaps like at 9 o'clock in the morning.
9 o'clock.
So he goes at 9 o'clock. That way it's early. He can stay for as long as he needs to do it. And then if you guys can also provide me with an address of where he needs to go, what floor, perhaps give me a contact name and number just in case as well. So your investigator. That way, if he should have any issues, he has a contact to be able to speak to someone as well. Because if he tries to go through the regular phone system to talk to man, he'll be beating his head against the wall. Okay, so just hang tight with me, Mr. Emitom. I'm going to have him talk to the investigator, see what time, make sure 9 o'clock tomorrow is good. We'll find out where you need to go. We'll give you a sheet of paper with time, location, and a contact for you. You go review everything. Our case is now 11/20. Today's November 20th. Do you want to set it for after the suppression hearing, since you guys are going to do that over there?
And honestly, I don't even think that the marijuana was sent to the lab, Your Honor. So
I put in a lab request, Judge, myself. I'm not sure if the officers provided it, but I put in a lab request.
okay, if you put a lab request, like I don't know when.
We'll cross that bridge when we get there. If the officers aren't doing what they're supposed to be doing, go. You know how I feel about that. So how do you feel about that? We'll set this case maybe one day after your hearing upstairs on the 12th.
Yeah.
And like they said, if you win that hearing, this case goes away. Yeah. If you don't win that hearing, then we'll deal with this case the day after and see how we move forward. Okay.
Okay, thank you, Your Honor.
All right, so we're off the record. All right, so just hang tight for me. I'm going to get all the information for you and then just look at everything that's out there. All right, got to. Okay. Okay. All right. Good luck, Mr. Emitom.
Well, guys, we have come to the end of our proceeding. And as we can see from the competency hearing that was given to Mr. Emitom, he was found competent to represent himself. And even though he has the opportunity to represent himself, it was asked if he wanted to at least have standby counsel, which he denied. But we see later on in this proceeding, he struggles to figure out what it is that his witness needed to do or need to do. And we see him trying to kind of try to get Judge Fleischer to kind of hint for him what needed to be done. And Judge Fleischer was like, no, this is what you asked for. This is what you wanted. It kind of shows that he should maybe at least take standby counsel. And also we saw Judge Fleischer talk to the prosecutors about the police making sure they do what they need to do when it comes to this case. And we see a lot where the police officers dropped the ball in many of the other cases by not showing up and allowing some of these sovereign citizens to walk because they didn't show up. But in this particular case, it has nothing to do with showing up, but with more dealing with providing evidence. So we'll see how that works out. This case actually or this particular continuance was actually a couple days ago. And I tried to find it. I tried to find the update on it. I have not been able to find it yet, but as soon as I do, I will share that with you guys. But the case is definitely still ongoing, and it probably will be ongoing for a while. So hopefully eventually we'll get some of these videos out of the Texas court system so that we can just find out what the conclusion is with this particular case. And with that being said, guys, that's all I have to say on today. This is Sovereign Citizens Hall of Fame. And for now, guys, Sovereign Citizens Court is adjourned. God bless.
I'm not threatening you. Say one more word and that's 30 days. 30 days.